Not yet.
Now it is.
Oh my God.
Please mute your microphone. Okay. Thank you. I think my recording is now up. Sorry. My recording is now up. So let's proceed to discuss what I was discussing. So when it comes to derivative suit, guys, we're simply saying that you are now suing on behalf of the company. Remember the rule when it comes to companies. Companies can sue and be sued in their own name. Okay. So the general rule is you as a member of the company, you can't sue on behalf of the company. Why? Because as a corporate body, the company can sue and be sued in its own name. So we don't need you to sue on behalf of the company because the company can sue on behalf of, I mean, on his own behalf in the company's own name. Now, why then do we bring derivative suits? We bring derivative suits in an instance or in instances where the company is not able to bring the suit on its own. Why? Because the majority members who are supposed to bring the suit or who are supposed to pass a resolution to bring that suit are the same people that are squandering the company to the ground. So if the majority are the ones that are doing something that is wrong to the company, then you can go to court and bring a derivative suit and tell this court that, hey, I'm a shareholder in this company. I'm bringing this suit on behalf of the company, of course, in the name of the company, because the company is the proper plaintiff, because of the following reasons. And then you give the reasons why you are suing the director or the reasons why you are suing that third party. So that is derivative suits. Now, also I've mentioned that when you go to court under the first instance, which is the protection of members against prejudicial and unfair conduct, then if the court is of the opinion that this thing that you're suing for is actually one that affects the company as a whole, then the court will convert that suit to become a derivative suit. That is a derivative suit as well. And then, of course, the other thing I need to mention that I forgot to mention is the question of liability of former directors. So again, if you are a director in a company, then just to understand that any person that is a director will be liable, okay, for all the debts that were incurred during the time that he was a director in the company. Are you together? That is the first rule. That is the rule. That is rule number one. Number two, this person is also liable for debts that have been incurred within the 12 months when he left or after he has left. Okay, so that is liability of the former directors. We'll talk more about that at the end of this class so that we are all on the same page. Now, at this very juncture, whatever that means, I want us to go and talk about the question of partnerships. Let us talk about partnerships. Partnerships is the easiest. Okay. Why are you guys laughing? I've said whatever that means. I don't know what it is, but I've just said it. Wherever it came from or whatever it means, I don't know. All right. At this juncture, I don't know why they said it like that. So fine, let's talk about partnerships, the law of partnerships. So what is partnerships? Very, very important for you to understand partnerships. I want us to go quickly through partnerships and then jump straight into mergers. But I've just remembered, before we go to partnerships, there's something I failed to mention about bankruptcy and insolvency, that when it comes to bankruptcy, as a process or as a procedure, you also need to understand the question of distribution. I mentioned this in the last in the class, that is the class in the afternoon, but I also think that you guys have not checked it out. So the question of distribution, and that is the distribution of the estate of the bankrupt. How do we distribute that estate of the bankrupt? Okay, that is exactly what I meant by distribution. So when you go to the second schedule, 246, you'll find the priority. Okay, now the priority is that preferential creditors are usually preferred and then followed by secured and then unsecured. Are you together? So when you go to that schedule, you're going to find now the priority of preferential creditors. Now, not all creditors are the same. Not all creditors are all equal. Some creditors are more equal than other creditors. Okay. For instance, when you talk about the three groups, the preferential creditors will be up. When you talk about the preferential creditors alone, then some preferential creditors will be higher than others in terms of priority, including, of course, this number one on the very list are the employees. The employees are the most revered preferential creditors of all the groups. So employees, child maintenance, any payment to the spouse, and then we go to tax and all those things. Those are preferential credits. And then from there, we shall proceed straight into secured. Whatever remains, we take to the unsecured, and then whatever remains, we shall take to the we shall give the surplus to the bankrupt. That is something also that you need to understand. And then, of course, the question of the bankruptcy notice, where you notify that this person has been declared bankrupt and all the stuff. Yes, please mute your microphone. Thank you. That is a bankruptcy notice. And then, of course, I had failed to mention, somebody asked a question on the insolvency practitioners. Before I forget, let me just mention them, insolvency practitioners. Now, in terms of insolvency practitioners, these are people that practice insolvency. Just like in conveyancing, we have conveyancing practitioners such as surveyors, we have planners, we have advocates, we have architects, we have the QSS. So all those are professionals within the conveyancing. Also, when it comes to this angle of insolvency, we also have insolvency practitioner, people that practice the law of insolvency. Okay, they are experts when it comes to the law of insolvency. Now, these people are trustees, administrators, liquidators, supervisors. Okay. Another thing about these people is that all of these people are supervised by somebody called the official receiver. The official receiver is like the father of all insolvency practitioners. So on top is the official receiver, and then we have all others here. Number three is that all insolvency practitioners or any person can act under any position at any given time. What I'm saying is this: if you are an insolvency practitioner, this week you could be a trustee. Please mute that thing. You can hear it. Okay. If you are an insolvency practitioner, this week you could be a trustee, number one. Next week you could be an administrator, or you could be a supervisor. So your role will keep changing depending on the assignment. So you can find a trustee becoming a liquidator. All right. Now on the side of bankruptcy, we have only three people: the head, which is the official receiver. Number two is the bankruptcy trustee, which some instances will come as an interim trustee. And then after that, we have the supervisor. The supervisor is the one that is in charge of supervising the voluntary, sorry, not the voluntary, but the alternatives of bankruptcy. So the person that supervises the alternatives to bankruptcy is the one we are calling the supervisor. So make sure you understand that. So interim trustee, supervisor, and then overall we have the official receiver. So when it comes to liquidation as well, insolvency as well of companies, we also have around three. Okay, we have four: the official receiver, which is the head again. We have the administrator, we have the liquidator, and then we have the supervisor. The liquidator, liquidation; administrator, administration; supervisor is in charge of voluntary arrangements. Guys, that is that. Then in terms of their qualification, the obvious qualification: they must be above the age of 18, they should not be bankrupt, mental capacity, must have a degree from a recognized university, must be a member of a professional body, either Law Society of Kenya or maybe the ISPAC or the answer for this ICS. And then must also, if they are an advocate of the High Court of Kenya, they must have worked under the office of the official receiver for 2 years. If they're not advocates, they must have worked under the office of the official receiver for 4 years. They must have 5 years professional experience, So such are the things that we are talking about. That's the qualifications of all of them. So whether it is a supervisor or a liquidator or even a trustee, the same. the same qualifications. So I hope that is clear in as far as that is concerned. Now, when it comes to powers and duties of there are two people we are calling the liquidator and administrators. What are their powers and what are their duties? The duties are the same, of course, with a trustee, but of course, in this instance, we're dealing with companies. Okay. So again, what are the powers and duties of those two people? The same duties, the same powers. Find that out. Now, let's talk about the question of partnerships, the law of partnerships. Partnerships are very simple. Don't complicate partnership, guys. Now, I also want you to do something. Let us do something. Let us be honest. And this could be the last, second last, so if not third last. Yeah, this is the third last exam. So there's no need of you getting turning away. Now, take a pen and a paper. As I go through each and every topic, please note down the questions that you have that are not making sense for you. And then we are going to go through them at the end of this session, one by one, until all your questions are answered. I'm not able to help further than that if you don't ask a question. So please make time, note down your questions, and then I can answer that if you ask. That is the easiest way to deal with questions. So please make sure that you record your questions and then we can address them at the very end. You know, please. If you don't ask that question, you're going to find it in an exam tomorrow. You will be sweating tomorrow. I'll be sleeping. Okay. So ask right now so that we can all address the issue, and then you go to the exam and you are able to answer the question. But if you don't answer the question because you think like you're shy or something, that is how you find that question in an exam, and then you start regretting. Okay, so please just ask the question. Okay, make sure that you ask and answer. Get an answer for that question. Now, partnership. The role of partnerships is very clear. The law of partnership is very clear. The rule in terms of partnership as well, very clear. So let's run through that. So the first thing we want to talk about is what are these things that will tell you that this is a partnership? What are these things that will tell you that these are partnerships? Okay, that is the first thing I want us to talk about. Please mute your microphone. We have been very peaceful. I want us to remain like that. I want us to remain like that. Thank you very much. All right, so let's go back and talk about partnership. So I was mentioning that in terms of partnership, it is the easiest. Partnerships are the easiest in terms of after MPSR is partnerships. Very simple. Mergers, very simple. Very simple things. Okay, it is direct to the point. So partnership is just a relationship between two parties. Okay, doing business together for purposes of making a profit. Okay, that is the law of partnerships. So what do you first need to understand? The general principles or the general features of a partnership. Now we have three types of partnerships, but the principles that I'm about to discuss are principles that cut across the board, and therefore when you see them, you will know it is a partnership. Are we together? You will know that this is a partnership. So please, let's go. The first one is the question of two or more people. So there's no partnership with just one person. And this one should be heard clearly. When you're on your tent, there's no partnership with just one person. Ni wewe nakuongelesha. Unajijua. Wacha kuforce issues. Kama uko peke yako kwa hiyo partnership yako, that is not a partnership. Even the law is very clear. There must be two or more people. Two or more. Are you together? So kama ni wewe peke yako, please move on. Okay, that is the law of partnership. So the first thing is two or more people. Now, of importance, as I explained this point, is this. For every partnership to exist, there must be two or more people. Okay, number one. Number two, they're doing business. They must be doing business. Number three, with an aim of making a profit. It doesn't matter whether they're making losses, but they're doing business with an aim of making a profit. That is that. Now, what then happens if the number falls below two? The minimum is two. Okay, but what happens if the number falls below two? Very, very simple. Now, in general partnerships and limited partnerships, okay, in firms, we call them firms. In firms, when the number falls below 2, okay, in a firm, when the number falls below 2, then the partnership will stop existing immediately. When the number falls below 2, the partnership will stop existing immediately, and the remaining partner is only allowed to keep doing business for 1 year as they wind up and pay the debts of the business. Okay? They wind up and pay the debts of the business. Are you together? So when the number falls below 2, you as the remaining partner, you close down the business, but you are allowed a maximum of 1 year so that you can keep paying the debts of the business, and then you close down. Now, during this period of time, you are not allowed, number one, to enter into new contracts. You're not allowed to take new debts. You're not allowed to take sign new responsibilities. You are not even allowed to take in a new partner. You can't take a new partner even during this stage. Okay, so that is the requirement. So when the number falls below 2, you close down the business within 1 year. Now, if you do business for more than 1 year with the same business partnership where a person left, resigned, or died, then after the 1 year, every debt that you incur will be you will be personally liable for all the debts that are incurred after the 1 year. That is the that is the law when it comes to the farms. Now, when it comes to the LLP, it is different. It is now 2 years. When it comes to LLP, if the number falls below 1, sorry, below 2, then you have to do business for 2 years, or you should do business for 2 years, and then after that, you close down the business, pay the debts. The same rule applies. That is the first one. The third one and the fourth one. That is the first, second, and third. Two people doing business together with an aim of making profit. The next one is the question of sharing of profits. Now, the general rule in all partnerships is that the profits will be shared equally at the end of every year. Okay, the profits will be shared equally at the end of every year. So if you see the question of sharing profits, that is a partnership, and we have said that this sharing of profit doesn't have to be equal. The partnership agreement can alter it and say that the first partner will take 50%, the second partner 30, and the fourth partner maybe 10. It doesn't matter. The partnership agreement will always have an altering effect should they decide to do that. Are we together? That is the question of sharing of profits. Now, after sharing of profits, what else do you need to understand? The question of remuneration. This also is constant across the board. So partners are not entitled to salaries. Partners are not entitled to salaries. Why are partners not entitled to salaries? Because partners are partners. They are the owners of the business. They are the business, and therefore they are not employees. And for that reason, they are not paid salaries. That is important. The third one is the question of capital contribution. Now, in this instance, also we are saying that the capital contribution of a partnership will be agreed upon by the partners. The partners will agree on how much they will contribute as capital contribution. Now, what is the rule on capital contribution? What is the rule on capital contribution? Okay, so the rule on capital contribution is very simple. Okay, what does it say? It says that number one, partners must agree on the minimum or the maximum capital contribution they will contribute. That is number one. Number two, that no partner shall be entitled to interest on capital. Interest on capital. What is interest on capital? If I'm a partner in a partnership, I give in my capital contribution, let's say 1 million shillings. So all the three partners, we contribute 1 million shillings. None of us is entitled to any interest on that capital contribution. Okay, and then thirdly, the third rule in terms of capital contribution is that should any of us contribute more than the rest, if you contribute 1.5 when others are contributing 1 million, then you will be entitled to a 3% interest on that additional amount. So if you contribute 1.5 and others contributed 1, then you will be entitled to 3% interest on 500,000. So whatever you add, whatever the additional amount you bring to the business on top of everyone else, you get 3% at 3% interest. Now, This is a question that can be set. You can be told that this partner contributed this partner contributed this. From that, proceed and calculate their capital. I mean their pay at the end of the year. Should they be dissolving the partnership? How much is James supposed to get? How much is John supposed to get? Now the rule is very simple. Everybody will get their capital contribution without any additional interest. Okay, everybody gets their capital contribution without any additional interest. However, for the person that contributed more than the other or more than the others, they will get 3% of whatever they contributed. So 3% annually for for every additional top up or additional contribution or the extra contribution, like I've already explained. However, also know that these are gentle rules. These rules can be altered by agreement. So the partnership agreement can say that partners will be entitled to 20% interest. That is partnership agreement. So without the partnership agreement, there is no um, capital. Interest on capital contribution. I hope that is home, and I hope that is clear. Now, okay, thank you. Now, the next thing that you need to understand also is a question of decision making. Decision making in a partnership is deemed to be equal, that every partner will have an equal footing to participate in the decision making of the decision making of the partnership. So it's a business. You guys are partners, so you contribute towards your decision making. Each person will be contributing. And then the last principle that I want us to talk about is the question of change of partners, which applies again also across the board, change of partners. So in terms of change of partners, what are we saying? We're simply saying that there are three instances where change of partners will happen. The first one is the question of admission of new partners. How do you admit new partners? Now, in terms of admission of new partners, the rule is very simple, that every partner must agree when you are admitting a new partner. Now, that is express or by conduct. Express or by conduct. Are you together? So what am I saying? That if you want to add an additional partner, then all the existing partners must say yes. Even if there are 20 and one say no, that is a problem. If you are 1 million and one of you says no, problem. If you are 199 say yes and the one says no, that's a problem. So all of you must agree. Now this agreement, this consent must either be expressed or implied. How is it implied? Like the question in 2021, how is it implied? That you agree with this person, you give them an office, you give them a file, for instance, you give them work, you accept their capital contribution, even though you've not told them expressly that, hey, we accept you as a partner. By the fact of your conduct, it looks like you've accepted them. So the concept can be expressed or can be implied. Are we together? So that is clear. That is clear. And I want us to move to something else. Now, I've talked about the question of sharing of profits. I've talked about the question of remuneration, capital contribution, decision making, change in partners, that is admission. Now, the other one is the question of resignation. So again, change in partners may resign. That is another change of partners. A partner may resign. The rule is very simple. If you're going to resign, you must give a 3-month notice before you resign. That is very clear. Then we have the question of expulsion, that a partner may be expelled from the partnership. How do you expel a partner from the partnership? There are two ways you're going to expel a partner from the partnership. The first way you can expel a partner from the partnership is where the partner has been declared bankrupt. The partner has been declared bankrupt, that is in the general partnerships and the limited partnerships. The partner has been declared bankrupt, or the partner's contribution in the business, that is the capital contribution, has been attached by a court order, for instance. Okay. Number two is where the court has made an order under Section 44, removing the partner. So if the court makes an order of removal, then the partners will vote to remove the partner. So that is a question of expulsion. That is also as clear. Now, all those rules that are mentioned up to now, they can be altered by the partnership agreement. So the partnership agreement is somehow superior to the act. The partnership act is just a guiding principle, but because partnerships are contracts, the parties to the contract, which are who are the partners, can always agree on how to deal with their question. They can say all partners will get a salary of this much every month. They can always say that every partner will get an interest on. So what I'm saying is this: every person can agree to whatever or whichever way they want to do business. Are we together? All right, that is clear. That is very clear. Now, let us talk about now the types of partnerships and the difference between those types of partnerships, and then we shall be nearing the end of partnership. It's a very simple thing, by the way. Don't confuse partnerships. So there are three types of partnerships. There's the general partnership, there's the limited partnership, and then there is the LLP. Okay, there's the LLP. Now, general partnership is on the left extreme, and LLP is on the right extreme, and then limited partnership is a mixture of both. I will explain how or why. So in terms of general partnership, this is the basic form of partnership that exists. That is general partnership. The basic form of partnership that exists. That is a general partnership. Are you together? That is that is a general partnership. So I want us to develop the four things that we're going to talk about in terms of differentiating the three. The first one is the question of liability. So let's start with the composition. Actually, liability. Liability first. Liability first. The next one is composition. Composition. The other one is management, and then registration. Are together? So those are the four items we are going to use to rule out the types of partnership that we have. Sorry. Now, the first one is the question of liability. Now, in general partnership, all partners will have unlimited liability. All general partners will have unlimited liability. That is in general partnerships. Let's go to limited partnership. So in limited partnership, there are two types. There are two types of partners. Okay. General partners will have unlimited liability, and then limited partners will have limited liability. There's a mixture of both. So if the question was to come and you had asked that James and John are trying to form up a business, a vehicle, and they're saying that both of them want to have unlimited liability, that question, if it narrows towards the question of partnership, then in that instance, that is a general partnership. If the question was to say, James and John are saying that James will have limited and John will have unlimited, then that is a limited partnership because it has both. But if the question was to say that both James and John are indicating they want to have limited liability, all of them, then that is an LLP, because it is only in LLP where you're going to find all partners having limited liability. Are we together? That is very clear. That is very clear. So please make sure that you understand that concept from the root of it to the end of it. So that is the question of liability. That is how you categorize the two, the three types of partnerships. The second one is the question of composition. Now, when it comes to general partnership, it is composed of general partners. When it comes to limited partnership, it is composed of both limited and general partners. When you go to LLPs, it is composed of limited liability partners, limited liability partners. So that should also be very, very clear. The other question is the question of management. So when it comes to management, what are we saying? We're saying that in general partnership, management is done by all partners. All partners will participate in management when it comes to general partnership. When it comes to limited partnership, that is the one in the middle, it is only general partners that will have the day-to-day management of the business. That is the general partners. Limited partners are not allowed to participate in the management of the business. So a question will say James and John. They have agreed that James is the only one who will be taking part in running the business, while John will just bring the capital. That is a limited partnership because only one person is taking part in the management, and that is a general partner. And we say that general partners have unlimited liability. And then, of course, in LLPs, there's a question of the managing partner, that in every LLP, there must be a managing partner, a partner that is in charge of managing the day-to-day affairs of the partnership. So if you are going to register an LLP, you must have a provision for the managing partner. So that is the question of management. And then in terms of registration, again, general partnerships are not registered, but they can be registered, as well as limited partnerships must be registered, as well as LLPs must be registered. We'll talk about registration in a few, but just make sure that you get what I'm saying until that point. Now, the next thing that I want us to, I hope you guys are taking notes, not really notes, but I hope you guys are noting down your questions, what is not clear, so that when I'm done, you can ask. All right, so let's go to the question of breakup of partnerships. What happens? What makes a partnership to break up? You know, what makes up a partnership? I mean, what causes a partnership to break up? You know, who wants to volunteer and tell us the sad stories of what happened? Yule mwenye ulikuwa na post kila mahali. What happened to both of you? Post kila mahali. Hatuwezi pumua. Look at yourself now. You're back to sleeping alone. Anyway, sawa, nobody wants to volunteer and give us their love story. Leah, do you want to volunteer? Bernard and Rachel and Leah, you want to give us your sad stories? Please don't traumatize us. We have exams tomorrow. Don't traumatize us with your love stories. All right. Sawa. So what instance or under what circumstance will a partnership break up? They will always break up. Partnership will always break up. Hata hiyo sahihi, hiyo yenye uko nayo sahihi, taisha tu, usijali. Time itafika. Partnerships will always break up. It is within the law, even in the Bible. Hata hiyo yako sahihi, ni time tuna count. Are we together? So the first one is, of course, the question of a court order. A court can order that a partnership to break up, that this partnership is no longer serving the interest of the public or the interest of the parties concerned, and therefore we need to break it up so that every person goes their way. The second one is the question of number falling below 2. If you are partners, again, if the number falls below 2, again, you can't be in a partnership alone. It is never a partnership. So you have to close down the business. Okay, number falls below 2. And then we have a unanimous decision. Okay, a unanimous decision that you've decided that, hey, this is the end of us with this business. Let us end the business here and proceed and do other things in life. Are we together? So that is a unanimous decision from all the partners. From all the partners, that will also end. Will also end the partnership, and most of the time it's because the partnership has achieved their purpose. Maybe it was for a specific period of time. The time is gone. Sorry. All right, the time has gone, or it was 5 years. 5 years is over. So parties must go home, okay, and do other things. So that is the question of breakup of partnerships. That is breakup of partnerships. So at least understand that as well. And then, of course, the other thing you need to understand is what are some of the powers the court will have when it comes to a partnership. Powers of court in a partnership also is a very common question that you need to understand. What are some of the powers? What are some of the orders the court can make when it comes to partnership? The first one, the court can order that the partnership to break up. That is the first one. The second one, the court can order that a party be removed. The court can order that a party be removed from the partnership. The court can order compensation to a partner. The court can order that cost be paid, or so not cost, but really damages be paid to a partner. The court can order that, for instance, a party be added as a partner. So the court has a wider net of latitude in terms of what the court can do. So if you are dealing with a question of partnership and the question is asking about what the powers the court will have, then of course you know that there are so many things that the court can do that you need to understand. The next thing that also we need to understand is the question of the partnership deed. This is very simple, guys. If you are going to have a partnership deed and the question is asking you what are some of the things you'll be negotiating in a partnership agreement, then it is very simple. Anything that you guys agree on, the parties, sharing of profits, remuneration, dispute resolution, the management, everything you can think of, that will be part of the partnership deed. Okay. And then lastly, I want to talk about the question of assignment in terms of general partnerships and generally partnership in terms of limited partnership as well. What is assignment? Assignment is whereby a partner assigns their share in the partnership to someone else. Not the share that we have in companies, but their share of the business. Their entitlement to the business, they give that to somebody else. Okay, that is the question of assignment. So what should you know about assignment? Assignment is very simple. This is an instance where, like I've said, could be a spouse, could be a man, not bequeathing, but really assigning his shares in a partnership to his daughter or son, whatever. That is assignment. So what is the consequence of assignment? When you assign your shares in a partnership, you stop being a partner. When you assign your shares in a partnership, you stop being a partner. So you are an assigning partner, and then the party that you've signed your shares to will become the assignee. The party will become the assignee. Are you together? So what are the entitlements of the assignee? What can the assignee do? What can the assignee do? What are the sorry about that. Okay, so what are some of the things that the assignee can do? What are some of the things that the assignee can do or will be entitled to? So the first one is the assignee will be entitled to the share of profits. So at the end of the year, because every partner is entitled to a share of profits, should there be profit, then the assignee will be entitled to the share of profits. Number two, the assignee will also be entitled to receive all the share of the assets if the business is being dissolved. If you're dissolving your business, then the share of the assets that was supposed to go to the assigning partner will now go to the person we are calling the assignee. And then of course there are things that the assignee cannot do. What can the assignee do? The first one, the assignee cannot become a partner without the consent of all partners. Are we together? Without the consent of all partners. So you can't say that because your husband is the one that assigned you the shares in that partnership, you become a partner. No. When it comes to partnership, there is nothing like that. You must be added as a partner by consent of all existing partners. Okay. Number two, you can't take part in the management of the partnership. The assignee cannot take part in the management of the partnership. And then lastly, the assignee cannot inspect the books of accounts of the partnership. So that is the question of assignment. Now, quickly, let us go to the question of limited partnerships. Limited partnerships. If you have a question, note it down so that you don't miss the point. So note the question down. I will give you time to ask, and then we shall address all of them. So the question of limited partnership, we're done with general partnership. So guys, all other types of partnerships, that is limited partnership and LLPs, they're going to borrow the principles that we've discussed. These principles apply to general partnerships, but they also apply to limited partnerships and also apply to LLPs. So the mother of all partnership is the general partnership. How to get that? And that's why in a question, if you see a question that you think is a partnership, then it is a partnership. It's a general partnership, unless otherwise. So consider the general partnership as the house. So the moment you open the house or the door to your house, that is the general partnership. Okay. So LLP can be the bedroom or the kitchen. The limited partnership could be the balcony. So what I'm saying is this: the mother of all partnership is the general partnership. So all the principles applicable in all the types of partnerships are the same principles that are applicable here. It is only that when it comes to limited partnership, we just limit something small. When it comes to LLP, we just switch something small, but they're the same principles that will apply across the board. So limited partnership, what do you need to understand about limited partnership? The first thing is the question of limitation. What is this thing that is limited here when it comes to limited partnerships? So the first thing that there are two things that are limited. The first one, if we call a partner a limited partner, what is limited about them? Are they short? Or what is that is limited about them? The first one that is limited when it comes to the partners that are called limited partners is the question of their participation. In fact, the only reason we call them limited partners is their participation. The limited partners are limited to the extent of their participation. They cannot participate in the day-to-day running of the business. They are in the background. They are in the background. They give the money, They wait until the end of the year, they come back, and then they share in the profits. That is clear. That is clear. The second thing that is limited for them is their liability. Their liability is limited to the extent of their capital contribution. You can't be a limited partner if you don't have the money. You must put in some money, then you become a limited partner. And then your liability is limited to the extent of your capital contribution. So it means if something were to happen, then we take your capital investment, that is your capital contribution, and that will be it. Right together. So that is their limit, their limits. The second thing that also you need to understand is what can they do? Okay, that is under the second schedule. What are some of the things that a limited partner can do? Guys, what are some of the things that a limited partner can do? And now that I'm mentioning that, I've also remembered the first schedule of the Partnership Act that provides for some of the things that does not confer partnership. Okay, some of the things that doesn't confer partnership. So remember, partnership has the question of sharing of profits. So if we are sharing profits, ordinarily we are partners. However, when you go to the second schedule, now it talks about some of the things, some of the transactions that will not confer partnership. The first one is just the question of if you are sharing a profit, the share of profit. When you receive a share of profit from somebody, doesn't make you their partner. Okay? Is that whole? The fact that somebody is giving you something small, a share of the profit, doesn't make you their partner. Are you together? So for instance, you are a supplier. So I'll do my business. I'll do the business. At the end of the day, or at the end of the month, or at the end of the year, out of my profit, I will say, hey, take this much for maybe something you're supplying, or maybe something that you're doing, or maybe I'm just being nice. That doesn't make you my partner. So read the first schedule and the second schedule. Now the second schedule talks about the question of some of the things that a limited partner can do, such as they can participate in the addition of other limited partners. If there's a limited partner that is supposed to be added, then that person, a limited partner, can participate in that decision. Number two is the question of changing the structure of the business. If you want to change the structure of the business, you have to involve limited partners. Number three is if you're changing the object. If the business was just for purposes of maybe selling onions and you want to change it to selling shoes, then you have to involve all partners, including the limited partners. So that is that. The last thing about limited partnership is a question of registration. So the registration requirements of partnership. The first thing you need to know is what is the name of the partnership. What do you need to have? The first one is the name of the partnership. You need a name. Okay. The second thing that you need to have whenever you're going to register a partnership is the question of the proposed nature of business. What is the nature of the business? Number three, if it is a limited partnership, remember there are two partners. The name and details of general partners. Number three, name and details of limited partners together with their capital contribution. You need the registered address. Okay, so those are things you need whenever you are registering an LP. That is a limited partnership. The name of the partnership, the proposed nature of the business. You need the proposed general partners, the name and details of the proposed limited partners together with their capital contribution. Okay, because we said what makes you a limited partner is the money. Okay, what makes you a limited partner is the money. So that should be very clear. That should be very, very clear. Now, this application is forwarded to the register of companies. Remember, we don't have a register of partnerships. We only have a register of companies. Are we together? All right. So somebody's having the video on. Please, Zima. All right, so that is limited partnership. Let's go straight into LLPs and add something on LLPs. Now, LLPs will have all the features that we discussed as well. So we don't need to go again, talk about sharing profits, capital contribution, and all that. No, the nature of LLPs, nature, feature of, and advantages of LLP. Okay, once an LLP has been registered, it becomes a corporate body. capable of suing and being sued in his own name, can own property, can enter into contract, as perpetual succession, as a separate legal personality. Those are the features of an LLP. Now, those features are in in congruence with the features of a company. So again, one of the things that makes up an LLP is the features of an LLP, which is the question of the separate legal personality upon incorporation. Now, again, we've seen questions that have been set, and the examiner has used the word incorporation. It doesn't mean that every time the word incorporation is mentioned, it is a question to do with LLP. No, incorporation simply means the question of registration. To register is to incorporate. Okay, so incorporation doesn't mean all the times it is a company or an LLP. Even a general partnership can be incorporated. You can be told they're intending to incorporate. What do they need? Are we together? I'm hoping that we are. All right, sawa. Now let's talk about the question of registration. Now, in terms of registration, you just need to understand what information will you forward to the Register of Companies for the registration of your LLP. Okay, what kind of information do you need when it comes to the registration? So the same way we started with limited partnership. The first one is the name of the LLP, the proposed partners, okay, proposed nature of business, proposed registered address, and then of course you know very well when it comes to an LLP, there must be somebody called the managing partner. So the proposed managing partner. And remember also in LLPs, we can have companies that form partners, become partners in an LLP. You can have an LLP that is composed of, partners companies as partners. Sorry, companies as partners. So that is the question of registration of LLPs. The other thing that you need to understand about LLPs is the question of conversion. So in terms of conversion, we can convert two things into an LLP. Okay, we can convert two things into an LLP. The first thing we can convert into an LLP is the question to do with, time is going, is the question to do with companies. Okay, you can convert a private company into an LLP. So what are the requirements? What do you need to have for you to convert that into an LLP? Number one, in terms of the criteria, number one is that it must be a private limited company. Guys, you will be told that these people are the proprietor of this business. They want to convert their business into an LLP. Now, there are only three things you can convert into an LLP. The first one, you can convert a private limited company. Number two, you can convert a general partnership or a limited partnership. Those are the only things you can convert into an LLP. Are we together? Now, if you are converting to an LLP from a company, what is the requirement? So there are two things you need to understand. Number one, the prerequisites, the condition that you must meet before you convert, the eligibility. Number two, you need to understand the requirements for conversion. And then lastly, you need to understand the question of the effects of the conversion. So the first requirement is it must be a private limited company. Number one. Number two is that at the time of the conversion, guys, it means you can't convert a public company to an LLP. Okay? You can also not convert a private and limited company. Okay? Now, number one, a private limited company. Number two, at the time of the conversion, no asset of the company should be encumbered. There should be no security registered against the assets of the company. There should be no security registered against the assets of the company. Are we together? That one should be very clear. And then lastly is that all the existing shareholders must be the proposed partners of the LLP. No more, no less. What I'm saying is this: if you are converting from a company that has 10 shareholders, then your LLP in the first instance must also have 10 partners. So it means the shareholders existing in this private company must also be the same partners in the new LLP. You can't add new partners as you convert. Also, you can't convert with the 9. So if there's one of the people that you have in that company that is not interested in converting the company into a partnership, then they need to first sell their shares and stop being shareholders. That is when you can convert. Are we together? That is clear. That is clear. Now, what is
Kindly
the
pardon.
requirement? Okay, let me say that again. So I'm saying in terms of eligibility for you to convert a company into an LLP, what do you need? You need the following four things. The first one, it must be a private limited company. It must be a private limited company. That is the first one. The second thing that you need to understand is that at the time of the conversion, no asset of the company should be encumbered. What is the meaning of should be encumbered? We are simply saying that at the time of the conversion of this specific company, the assets, there should be no charge, no mortgage, no debenture, no MPSR on the assets of the company. Number three is that the existing shareholders in the company must be the only partners in the LLP. No more, no less. It means if the company had 10 shareholders, then your partnership, your LLP, must have the 10 partners. So it doesn't mean, it means that if you have 10, one cannot say that you guys are converting, Mimi, I'm leaving. No, they cannot leave when you're converting. You either go all of you, the 10 of you, or you remain here. At the same time, as you're going the 10 of you, you can't add another one along the way. You can't invite your friend and say, hey, come, let us be partners here. You can't. Just the 10 of you. You can't add more. You can't drop one. Are you together? That therefore means if there's your 10 shareholders and one shareholder is not interested in converting, you cannot convert until you buy them out. Until you first, they leave, you remain 9, and then the 9 of you can apply for conversion. Are you together? That is the rule. Now, what is the requirement? The requirement is very simple. The details of where you're coming from and the details of where you're going to. So what am I saying? The details of the company you're coming from and the details of the partnership you're converting to. What am I saying? I'm saying, hey, the name of the company you're converting from, the registered, the registration number and the name, and then the names of the proposed LLP, the name of the proposed partners, the proposed nature of business, the proposed managing partner, and the proposed registered office or the registered office. That is all. What is the effect? What is the effect of conversion? Once you convert, all assets, liability, rights, obligations will be converted or will be transferred to the new LLP as if they were incurred or acquired by the new LLP. So it means kama ulikuwa na deni ya mtu as a company and you convert into an LLP, bado utakuwa na deni yake kama hiyo LLP. Tunaelewana? So it doesn't mean that ukiconvert utasema sasa no, I'm a new person. I'm born again. No, you are not born again. Sit down. You owe that person money. Are we together? So that is the effect. Now the same rule, take it and apply it in the conversion of general partnership, limited partnership into LLP. The same thing. If you are converting from a general partnership and you're just 5 partners, all those 5 partners must agree to become new partners in the LLP. That is the eligibility criteria. Okay. And the next thing is, what are the requirements? The details of the partnership you are converting from and the details of the partnership you are now converting to. Okay. If it is a limited partnership, the details of the partnership you are converting from, that is the name of the LP, the registration number of the LP, if it has one, and then the proposed LLP name, proposed registered address, proposed managing partner. Guys, those are the things you need. Okay. Lastly, on LLPs, I want to mention the question of, again, the effects. The effects of conversion is if you are a general partner and you had a debt of 1 million and you convert into an LLP, that new LLP will have that debt of 1 million. So the debt, contracts, liability, rights, all those are transferred to the new entity. Lastly is the question of assignment. Now, We talked about assignment in general partnerships and limited partnership, where we said that when you assign your shares, then you remember that story. Now, this is a new story now. When it comes to LLP, it is a bit different. What is the difference when it comes to LLPs? The first difference when it comes to LLPs is this. Okay? The same way an assignee will not become a partner in an LP or a GP is the same way an assignee will not become a partner in the LLP. Okay? However, when it comes, everything remains constant. Everything will remain constant. But when it comes to the question of participation, the question of inspection of the books, that changes. So in general partnership and LPs, the assignee cannot take part in the management. The assignee cannot inspect the books of account. In LLPs, the assignee can inspect the books of account. The assignee can take part in the management, but they cannot become partners without the blessing of all partners. My friends, that is the end of partnerships. I want us to go straight into mergers and acquisitions. Unless somebody has a question that is so burning, I can only take 2 questions maximum. 2 that are so burning. And I'm wondering why you guys are quiet today. The last class, you guys are so chaotic. Are you guys scared? So, yes, you guys need to be scared. You shall see fire. Yeah. Any Manza too? I've just praised you right now. Manza too kupiga kelele. Martin, I'm just wondering, how are you listening to my class and that music in the background? Are you a witch doctor? I'm wondering how those two things can work. Maybe people are different. I don't know. All right, sawa. Let's take a question from Claire, and then Joy, and then Martin. No more hands should be up, and then Mobui Victor, and then Mutinda and Opande. No more hand should be up apart from the 5.
Okay, Jackson, my question is, if you're asked, what are the advantages of a partnership over a company, and what are the disadvantages of a partnership over a company? That's my question.
You want me to do the assignment for you? That is the first assignment I gave in this class. You want me to do that for you? Just go and Nanipima, umetumwa. All right, Joy which? That is something I can't even tell you. That is something you should know. Okay? Something you should know. The law of business in high school, business studies. Was it in high school? Yes. When people are discussing and doing business, some of you are not doing business in high school. You are doing home science, you are cooking. Now you're cooking, imekupeleka wapi sasa? Tell me. Your friends were doing home science. You are doing German. You are learning German. Sasa hiyo German unaongea na nani sahi? All your friend group, all your relatives don't speak German. The entire village doesn't speak German. Unajiongelesha kwa ndoto. Life choices, my friend. Ungefanya business studies sahi ungekuwa unang'ara hapa. But anyway, if you have children, please avoid doing funny languages in high school. But anyway, business studies, advantages of partnership and companies was part of the discussion. You see, that is our destiny. Nyota inakuacha tu kama unapika high school. Anyway, that is the assignment I gave in this class. Please take time and look at it. I've said it in all the 26 classes we've had, each and every single day. So please do it. Lea, tumesikizana. Mutinda or Joy next, and then Mutinda, and then Opande and Mubui.
Okay, thank you very much. I have 2-3 questions. The first question that I have is on when the...
How do you have 3 questions? You can only ask 1 question, not 3.
Okay, I'll phrase the question into one with connectors like and. Okay, in cases where when we talk about liability of the members, you stated that at the point where there's liquidation.
I'm not talking about company. Hey,
Okay.
no question is accepted on companies. Only partnerships for now.
Oh, okay, fine.
Okay. And you reminded me to the question of liability of partners. Again, guys, read liability of partners. Partners are agents of the partnership. Anything a partner does, so long as it's in the course of the partnership of the business of the partnership, it binds the partnership unless the partner did not have power to do that, and the third party knew the partner didn't have the power to do whatever they did. But nonetheless, they proceeded to do whatever they did with the partner. So if that is not clear, I will explain that again. Liabilities of partners, the partnership is bound by the acts of a partner, so long as the partner is acting in the normal course of the partnership business. Okay. What are the exceptions to that rule? The exception to that rule is this: where the partner did not have the power to act as such, and the third party that they acted with knew very well they didn't have the power to do that, and also, or they never knew that they were partner in the partnership. I hope that is clear. Let us talk to Mutinda. Chebet Milka, your hand should be down. I don't want more questions like if you're not part of the people that I already picked. Mutinda, please.
Yes, sir. Now, my question is in regard to limited partnerships, and more specifically in regard to sharing of profits. Let's say next year, after admission, I want to open a law firm, but I don't have the funds. Then I get a friend of mine who is a non-lawyer. Can
Just
we be
stop
partners?
there. Stop there. You are going to fail professional ethics, my friend. You're going to fail professional ethics. What do you mean your friend is non-lawyer?
It was in regard to limited partnership, not in regard to professional ethics.
You're going to fail professional ethics in your Shandika. You're coming from when Mutinda. You need to talk to your grandmother to correct that paper for you. Kama weni daktari kutoka wapi? Please, you can't have an advocate. That thing is unprofessional first. A non-lawyer and a lawyer can't be in a partnership. Whether it's limited, whether it is LLP, whether it is whichever general, you can't have a non-lawyer and a lawyer. That is unprofessional conduct. Sharing of profits in unqualified people. You can't. So that question is terminated there. Obui, Victor, and Opande, make it your questions very quick, very, very short. Guys, time is not on my side. Mergers and acquisition is the next thing. Obui, Victor, quickly.
Yes, I'd like to know the difference or what is the difference between management of a company and decision making in a company?
No question on companies.
Sorry, not
Opande,
company.
Willis. Opande.
Yeah, thank you, Victor.
Decision making is making a decision in terms of we are going to do this as a business. Management is the day-to-day running, signing of documents here and there, attending meetings here and there, signing checks here and there. That is management, day-to-day, the day-to-day. But in terms of decision making, these are if there are crucial decisions when it comes to the business, the decision that affect the structure of the business, that is decision making. So in partnerships, in companies, they're done by resolutions. But in terms of partnerships, every partner will participate in the decision making. But in terms of management, it depends on which type of partnership it is. Lastly, Opande, and then Manjas. Quickly.
Thank you, Jackton. I wanted to just get a clarification about. There is a question asking two partners who are in business and one has got a job and wants to resign. So you are told to advise the other one. Is it advising him because he wants to add more partners in that partnership? So is it
That question is not complete. That question is not complete.
Yeah.
Ask the question completely. What is the question?
Yeah, there were
Advise them on what?
Advise the remaining partner on what he can do in order to
On
add
what?
more partners.
You can't add more partners. You can't add more partners. Once the number falls below 2, the partnership must end. They have to dissolve the partnership, and then after they dissolve the partnership, you can go and form a new partnership with those other partners. You can't add more partners when the number falls below 2. If the number falls below 2, the partnership will dies. But before this person resigns, you can add new partners before they leave.
Okay.
Before they leave as partners, you can add more partners with their consent.
Within the 3 months?
Have they resigned?
Not yet.
Yes, if they're not resigned, they're still partners. So you can add new partners before they resign. But once they resign, they stop being partners. And therefore, you can't add. If the number falls below 2, you can't. So it's just the dynamic of that.
Thank you.
Mergers and acquisitions. What is a merger? So a merger is where two people come together. And these people are companies. They come together either through amalgamation. They come together through a full function joint venture. They come together through a takeover or an acquisition. So let me not confuse you and by mentioning a full function joint venture. We talk about that in a few, so don't worry. So in terms of mergers, what do you need to understand about mergers? The definition of a merger is where a company asserts control over another company directly or indirectly. So when one company asserts control over another company directly or indirectly, that would result into a merger of the two companies. Are we together? So the merger is the general term. And then we have forms of mergers, which includes the question of amalgamation, just two companies coming together to amalgamate and combine their forces. That is a merger. That amalgamation results to a merger. And then, of course, we have also the question of acquisition, where one company makes an offer to acquire another company, and that offer is accepted. And then now we have a takeover, which normally in almost all instances is hostile, where one company through hostility acquires the assets of another company, okay, or acquires the shares of another company. So those are forms of mergers. So the merger is the act of asserting direct or indirect control. Okay, we have seen questions asking you to define what a merger is. So make sure when that question is tried, you are able to understand that very, very well. All right, now apart from that, you need to understand the question of control. What is this thing control? How do you assert control? Now, how do you know that somebody has control? You will know that a company has control over another company. Number one, if they buy majority of the shares. That is more than half of the shares, that is majority, the controlling shares. Number two, if they buy the majority of the asset, that is the controlling assets, 50% of the assets. 50% plus one of the assets. That is more than the majority. Sorry, more than the minimum requirement for control, which is 50%. So if they have controlling shares or controlling assets, they have control. Number two, if they can fire and appoint directors. If they can fire directors, that person has control. If they can appoint directors, that person has control. If they can vote majority at a voting, they have control. If they can influence the policies of that company, they have control. So those are the things that will tell you under Section 4.1 that this company has control. That is clear. Why do people merge? Objectives of mergers. Again, a merger is one of the alternatives, not really alternatives, but one of the voluntary arrangements that you can have. Okay, one of the voluntary arrangements that you can have, so that if somebody owes you money as a company, instead of them, if they don't have money to pay you, then you proceed and merge with them or acquire them. And you've had marriages where people got married because of debt. She loaned you some money or you loaned her some money, kulipa ikakuwa ngumu, mkaamua muane tu, and you've been living happily forever after. That is good. We're happy for you. So again, that is one of the proposals in terms of voluntary arrangements in insolvency. The question can ask you, what are some of the things you can suggest? One of them is a merger, so that, hey, we don't have the money to pay you. Also, we don't want to go under, that is be liquidated. So just acquire us. Okay, that is also very, very, very clear. Okay. Now, apart from that, what else should you understand? What else do you need to understand apart from objectives of mergers? I've really mentioned them. Number one, of course, pool capital, avoid liquidation, expand the market base, expand the customer base, expand the capital base. So there are a lot of reasons why people merge. Avoid liquidity, avoid hostile takeover, avoid liquidation. So there's so many reasons why you'd want to merge. Okay, raise more capital. If you have 50, I have 50, we can come together and we can all have 100. Now that is the question of why parties merge. So the other thing you need to understand about mergers again is the question of documentation. We have talked about documentation in mergers and acquisition. So we have letters of offers, which is now letters of intent or letters of offer. This is a document that really shows the intent to acquire, that you want to acquire a company. You send them a letter of offer. You send them a letter of offer, offering to acquire them. Okay. That is letters of offers. And then apart from letters of offers, we also have the question of, sometimes letters of offers are called letters of intent, the intention to. Okay. And then after that, also we have the question of the term sheet. Now the term sheet is a sheet that carries the principal terms of that merger. The principal terms of the merger will be contained, okay, in a term sheet. So the term sheet, as the name suggests, carries the terms. Okay. After that, we have what we call the NDA, that is an undisclosure agreement. Guys, you can be told to draft these documents. They're just letters. You can draft them the way you want in your own language. So long as your language is English, all good. Okay. So long as your language is in English, all good. Are you together? So please, please, please make sure that you understand that. So just understand what they are. NDA is an undisclosure agreement where both parties agree that they're not going to disclose any information that they acquire as a result of that, a transaction or negotiation and all that. Okay, are we together? So that is clear. Now the next thing that also you need to understand, in terms of documentation is the question to do with exclusivity agreement. Exclusivity agreement is also called the no-shop agreement. So no-shop agreement is an agreement where we are saying that once the parties have started negotiating their transaction of this merger, no party can receive offers from another person, another company, or no party can give another offer to another company. So it means you can't go shopping, you can't go looking. Once you've started knowing this company, it is only that company that you can know until that knowing is over. Are we together? So that is what I'm saying. So if you receive an offer from Safaricom to acquire your company, you can't receive another offer from someone. You can't consider giving somebody another. So you are bound by each other. You are stuck with each other. That is what it's called, exclusivity agreement. And then we have now the question of the share purchase agreement and the business purchase agreement, which is the normal agreement. If you know how to prepare an agreement for sale of land, it's the same thing. Describe parties, describe the buyer and the seller, describe the purchase price, describe what is being bought. Are they assets or are they shares? Okay, if they're buying all the shares, the question will tell you they're buying all the shares. So in terms of the description of the property, it is all the ordinary shares. All the ordinary shares are of maybe XYZ Company Limited. Are you together? So that is clear in as far as what is an SPA or a BPA, that is the share purchase agreement and the business purchase agreement. Also, we have the due diligence checklist that contains the checklist of the things you need to confirm in terms of your due diligence. Are you together? So that is clear. The next thing is, let's talk about due diligence now. Also, there's a very hot topic in terms of mergers and acquisition, due diligence. What do you need to understand about due diligence? What is it that you need to understand about due diligence as you prepare your due diligence checklist? So number one, we have the 5 things that we normally go into a due diligence checklist. The first one, financial due diligence. That is the first, financial due diligence. The next one is legal due diligence. The third one is human resource due diligence. The fourth one is operational due diligence, and then the corporate due diligence. Okay, so legal, you look at all the legal matters, cases in court, decrees, judgment, rulings, investigation, complaints, all those. Okay. When it comes to human resource, you look at the employees, the number of employees, organizational structures, who are the directors, who are the supervisors, the managers, all that. Are they? You look at the employment contracts. That is human resource due diligence. If it is about operational due diligence, you look at the consumers, the customers, the market, the suppliers, distributors, competitors, advertisement, how do they market, all that. If it is corporate due diligence, you look at the directors, the shareholders, the members, the article of association, the memorandum of association, beneficial owners, the share capital, statement of guarantee, should there be needs. So you look at everything around the creation of a company. Okay, so that is that. If it is financial due diligence, you look at all the financials, that is the statement of financial position, the cash flow, the balance sheet, all those things. That is the financial due diligence. So guys, that is due diligence. We are not talking so much. It's a very direct thing that you understand. Now let us go now to the procedure of actualizing a merger. That procedure normally starts with the question of notification. Now notification is in two categories. The first one is notification on the competition authority. Number two is the notification upon the sector specific regulators or the sector regulators. Who are these? If it is a bank merging, the Central Bank of Kenya. If it is a listed company, a publicly listed company, is the Capital Markets Authority. If it is an insurance company, an IRA, that is Insurance Regulatory Authority. If it is a communication company, Safaricom, Airtel, we have the Communication Authority of Kenya, the CAK, or the CA. Okay, so please, that is the question of notification. And then we have the Competition Authority, which is now the overall or the decision maker when it comes to the question of approval and rejection of mergers and acquisitions. Are we together? That is clear. Now, in terms of notification upon the Competition Authority, what do you need to understand? The first thing you need to understand is that I don't know that I can bring up my screen or it will take much time. So you need to understand the documentation that must be provided when you're notifying the authority. So what do you need? A merger notification form. Number one, merger notification form. It is accompanied by, number one, the share purchase agreement or the business purchase agreement, certificate of incorporation of both companies, the details, or I mean the business plan of both companies as well. So we have looked at these documents over and over and over again. Whenever you are notifying the authority, then when you go to your guidelines, the competition guidelines, you'll find the documents that must accompany the merger notification form. Guys, are we together?
Yes, we are.
All right. So that is clear. That is clear in terms of the documentation, the mergers. Like I've said, you need to understand the documents that accompany the merger notification form, and those documents are listed under the competition general guidelines. That is of 2019. Okay. So if you go to that document that I sent you and you guys have it, it is available free of charge online. You'll find the document that are supposed to accompany the merger notification form. All right. Any concern? So what are these documents that I've mentioned? Somebody wants to recite them for us. What are the documents that must accompany the merger notification form? Okay, so you find those documents and then proceed and answer the question. But I've already given you the document, so anyway, you don't have any assignment to do in terms of that. Now, that aside, after the question of notification, you also need to understand the threshold. the merger notification threshold. Not all mergers are notifiable. Not all mergers are notifiable. Some mergers are not notifiable. Okay, some mergers are not notifiable, and therefore you don't notify them upon the authority. So I've said the first point is you need to know the documents. And I've said the documents are the merger notification form that is accompanied by the sale and purchase agreement. You must have the certificate of incorporation of both companies. You must have the statement of financial positions of both companies. You must have the annual reports, again, of both companies, which have been audited by, of course, an auditor, of course, not later than 3 years as well. You must have the returns. So all the documents you need, including the what you call the organizational breakdown. That is the breakdown of employees. Are you together? So that is clear. Now you need to know the threshold as well. What is the threshold in terms of notification? Okay, some mergers are exempt from notification, some are not exempted from notification. Are we together?
Yes, we are.
All right. So we start from the very from the bottom of it. So we have mergers that their combined turnover is from 0 to 500 million. These mergers are not are exempted from notification. Any merger that is from 0 to 500 million, they are exempted from notification. They don't need to notify the authority. They do not need to notify the authority at any specific point. Any merger that is between 0 to 500 million shillings, that is their combined turnover, then they don't need to notify the authority. Aside from that, somebody's asking a question in the chat. Somebody answer that question. Aside from that, they also another merger that is not notifiable is a merger that meets the COMESA threshold. A merger that will meet the COMESA threshold and not. No, what am I saying? So a merger that meets the COMESA threshold, the COMESA regulations in terms of the commercial notification guidelines, there are two things. There's the financials, and then there's the regional test. Now, a merger that meets that will not be notifiable if 2/3 of its combined turnover or value of assets is not associated with Kenya or not generated from Kenya. So that means a merger that is completely in a COMESA and 2/3 is not generated from Kenya, they don't need to notify the authority. The opposite is true. If a merger meets the COMESA threshold and 2/3 of it, of their combined turnover or value of assets, is generated from Kenya, they must notify the authority. Okay? So that is non-notifiable mergers that can't be notified. Okay, and then apart from that, now we have mergers that may be excluded from requiring the approval. It means they may be required to notify, but at some point, if they apply, they will be exempted. Okay, if they apply, they will be exempted. So they may be considered for exemption should they apply. Okay, that is what we are saying. So which are these mergers? Any merger that has a combined turnover of 500 million and one, or 501 million, or 500 million and 1 shilling. Okay, anything that's above 500 million but below 1 billion, their combined turnover, in terms of combined turnover or value of assets, they will be considered for exclusion should they apply. Guys, what am I saying? I'm simply saying that any merger, okay, that is above 500 million and below 1 billion, that is in terms of combined turnover, will be considered for exclusion should they apply. It means you qualify to be excluded, but you must apply. Below 500 million, you automatically qualify for exclusion. You don't need to apply. You don't need to notify. But above 500 million, you qualify for exclusion, but you must apply to be excluded from notification. And then mergers that have 1 billion and above, and their combined turnover is 1 billion. I mean, their combined turnover is 1 billion and above, and the target undertaking has 500 million. That merger is notifiable upon the authority. That merger is notifiable upon the authority. The other merger that is notifiable upon the authority is a merger where the turnover or value of assets of the acquiring entity is 10 billion and above, and the two entities are in the same market. So if the two companies are in the same market and the target and the acquiring undertaking has 10 billion, then they will notify the authority. And then, of course, companies that are in the business of what we call the carbon-based mineral sector, and the value of the assets or the reserve is 10 billion and above, they must notify the authority as well. And then lastly, a merger that meets the COMESA regulations or criteria, and 2/3 or more of their turnover is generated from or in Kenya. They must notify the authority. So those are the notifiable mergers, the mergers that may be considered for exclusion, and then mergers that are exempted from exclusion. Are we together? If there's a question, put it down. I'm going to ask. I'm going to give you time to ask that question in a minute. Let's go to the COMESA guidelines. Let's go to the COMESA one. So in terms of COMESA, it is very, very simple. In terms of COMESA, it is very, very simple. What are we saying in terms of COMESA? Number one, there are two things. For COMESA, there must be the financial test, and then the regional test. So in terms of financial test, then the combined turnover of both companies, that are trying to merge must be 50 million USD. Okay, 50 million US dollars. If you combine their turnover, it is 50 million US dollars. And each or at least two of the merging parties have a turnover of 10 million US dollars. So we're simply saying that, yes, first, both of you together must have 50 million, but also at least each of you must have 10 million each. What is the meaning of that? If one company has 45 and one company has 5, that is 50 million. They don't meet the requirement because the second company doesn't meet the 10. So the 10 is the requirement. If you're more than one company, if you're more than two companies, then at least two must have the 10 million. So we're simply saying that when you come to the table, both of you must bring 50 million. But at the individual level, each party coming to that table must, underline the word must have at least 10. If there are two parties, they must have 10 each, at least 10. If there are more than two, at least two of them must have 10. That is the financial threshold. And then when it comes to the regional test, is that each of the companies must be operating in at least 2 COMESA states. So company A must be in Kenya, company A must be in Uganda, okay? Company B must be in Rwanda, and company B must be in Zimbabwe, for instance. So two of the companies, both the companies must be operating in at least 2 COMESA states. Nyinyi wawili nitalia sana. Zima hiyo kitu. Okay. Thank you very much. So that is clear, guys. That is very clear. So in terms of, we are not saying that the two of them are in 2 different COMESA states. No, each of them must be operating in at least 2 COMESA states. That is the first requirement. Or if that is impossible, then the acquiring undertaking, the company that is acquiring the other, must be in at least 2 COMESA states. So that is company A is both in Kenya and Uganda, and then company B is the one that is in Rwanda or Kenya. If that is impossible, then the company that is being acquired, must be in at least 2 COMESA states. So what we're saying, guys, is that the regional test demands that at least one of the merging parties must be operating in at least 2 COMESA states. It is desirable if all of them are operating in both COMESA, in 2 COMESA states, but if that is not possible, then at least one of them must be existing in 2 COMESA states. That is the regional test. And guys, that is the end of mergers and acquisitions. That is all you need to understand until there. Okay. Now, the last thing I need to mention in terms of mergers, again, this is just the question. So you've notified. Now, the only thing that is remaining now is the approval of the authority. Now, what is the authority supposed to consider when they are rejecting or approving your merger? So the first one, of course, is the effect of that merger on employment, the effect of that merger on the local industries, the effect of that merger on competition, whether that merger will result into monopoly, the effect of that merger to the general public, the effect of that merger on research, development, supply of goods. So those are the things that are listed under section 46 that the authority will consider when rejecting or approving a merger. Okay, so once they consider those factors, they'll approve your merger within 60 days, or we reject your merger or approve your merger with conditions. That is the end of mergers and acquisitions. Guys, that is the end of mergers and acquisition. Please go through that as well. It's as simple as that. So please do not complicate them. All right. I don't want to take questions right now. Please note down your questions as well. Once I'm done, I will give you time to ask all your questions. We have only 3 topics to go. We are going to make them very quick and very fast. Commercial agreements. The first one is a joint venture. There are 2 types of joint ventures. So the first one is joint venture. So joint ventures, franchises, trust, guarantees, distribution agreements. We'll talk about that. And then we can go to something else, which is tax. And then we shall end with national payment systems. And I will take all your questions from MPSR, companies, insolvencies, and all that. So let's make this quick. And then we go to the next thing. So in terms of commercial agreements, the first one you're going to do is a joint venture. Okay, a joint venture might be set, may be set, never know. Franchise agreements. So commercial agreements are usually they are also good setting questions. Examiner likes setting these questions. So you want to understand, or you want to be very sure about that. So that is commercial agreements. So in terms of commercial agreements, the first one is a joint venture. So let's start with a joint venture. So normally there are 2 types of joint ventures. The first one is Greenleaf joint venture. Okay, a Greenleaf joint venture. This is very simple. This is whereby the joint venture is totally different from the parent companies. But let me introduce the question first. So when we talk about a JV, this is where 2 companies come together. 2 companies come together to form an entity. The entity is the joint venture. The entity is the joint venture. So 2 companies will come together. Okay, 2 companies will come together. Are you together? In coming together, the 2 companies will form an entity, and that entity is what we call a joint venture. Okay, now it is a Greenleaf joint venture if this joint venture is venturing into something that the parent companies are not doing. For instance, maybe the parent companies are Safaricom and Airtel. But now the joint venture they have created will be focusing on banking. So therefore, that joint venture is a green leaf joint venture. Okay, it is green. Green. When you're told the grass is green on the other side, you know what that means. Okay. Yes. So green leaf or greenfield joint venture. The other one is a full function joint venture. A full function joint venture is a joint venture that is independent of the parent companies. It means it is a fully functional joint ventures with its own structures, own directors, own management, financial departments, suppliers, markets. It is a full function. It means it does not rely on the parent companies. And even in that instance, a greenleaf or a greenfield, a joint venture can also be a full function joint venture if it doesn't rely on the parent companies. Now, in terms of that, what are the requirements for a joint venture? Number one, of course, is the question of the joint venture must be under control or must be as a result of a creature, must be a creature of the two parent companies. Okay, there must be the question of sharing of the sharing of profits. There must be the question of capital contribution. Are we together? So those are the requirements of a joint venture. But now, what are the key important things that you will negotiate thoroughly in a joint venture agreement? What are the contents of a joint venture agreement? That I think you guys know that very well. JV agreements, the things that should go into a JV. I am very positive and very clear that you know that. Okay, so I don't need to go to discuss them one by one. Okay, that is the joint venture agreements. Just the description of parties, the purpose of the joint venture, sharing of profits, capital contribution, management, dispute resolution, those obvious things, guys. Okay, that is that. Then we have a franchise. A franchise is an instance where a party sells or leases a brand and does business in that name or that brand in exchange of some consideration to them, to the franchisor. So we have we have two parties. The first party is called the franchisor. That is the owner of the brand. And the second party is called the franchisee, who is the owner of the franchisee is the person that is buying or leasing the brand, which is a franchise. Are we together? Now, what are some of the considerations you need to consider? You need to put in place as you set up a joint venture, sorry, a franchise, let's say in Kenya. What are some of the considerations? The first one is taxation, data protection, competition, okay, consumer protection as well, the market. So there are things you need to understand before you put up a joint venture. If you're bringing a joint, sorry, I keep mentioning a joint venture. If you're bringing a franchise from South Africa or from the US, whichever place you're bringing it from, you first need to consider those aspects as you bring that joint venture to Kenya. Now, in terms of the elements, in terms of what goes into the documents, a joint venture agreement, what will you have? What will you have when it comes to joint venture agreements? Okay. Now, the first one is, of course, the name and description of parties. Name and description of the parties, description of the joint, sorry, I don't know why I keep mentioning this as joint ventures. We are talking about franchise, guys, a franchise. So what are some of the elements or the contents of a franchise agreement? The name and description of the franchisor, the name and description of the franchisee, the name and description of the franchise, the purchase price or the lease, the rent, whatever you'll be paying, the consideration class, okay, the term, and then the question to do with the protection of IP, standardization, applicable law, dispute resolution, duties of parties, you know, all that will be will form part of all that will form part of a joint franchise agreement. And then we have a trust. A trust is very very important. Again, somebody is doing something charitable. They want to help the women in the community, the children or the girls. They are trying to come up with a drive. So that will be a foundation, which is also sometimes a trust. So in that instance, what do you need to understand? That there are three parties to that agreement. There's the settler, who is the person that is creating the trust. There's the trustee, the person in charge of implementing the terms of the trust. And then also we have the question to do with with the beneficiaries. These are the people that benefit directly directly from the the trust. Are we together? So in terms of the content of the trust deed, what do you need to have in the trust deed? Of course, you need to have the name and description of parties. Name and description of parties are very, very important. Name and description of the parties. Name and description of parties, very, very important. Okay. After the name and description of parties, I've said there are three parties. You have to give us the objective of the trust. What is the objective of the trust? You have to give us the beneficiaries. You have to give us the term of the trust. You have to give us the duties of the trustees. You have to give us the applicable law. You have to give us the trust fund. Where is this trust fund going to, where is the money for the trust going to come from, or what assets are comprised in the trust? You have to give us that. Dispute resolution, appointment of trustees, applicable law, all those things, the normal things you will have there in a trust. That is a trust. We have contracts of guarantee where somebody guarantees that they will make payment on behalf of somebody who has taken a loan. If you are taking a credit from somebody, normally the bank will guarantee you. The bank will send what we call the bank guarantee, telling you that, hey, with the bank guarantee that we shall pay this person XYZ, this amount of money, not person XYZ in the context of the person they're guaranteeing, but the person that is enjoying the guarantee, that is the beneficiary. Okay, so there are three people in the in the statement of guarantee or the bank guarantee. The first person is the beneficiary. That is the person that is receiving the bank guarantee. And then we have the person taking the credit, and then the person guaranteeing. So the guarantor, the client, and then we have the beneficiary. Okay, so in that bank guarantee, the bank is simply telling you that, hey, for instance, let's assume that you're dealing with Coca-Cola as a distributor. Now, if you are a distributor with Coca-Cola, then you know that every single time you take the Coca-Cola products, you have to pay for them. Okay, you have to pay for them. Now, if you don't have the money, then you can give Coca-Cola a bank guarantee. So the bank will guarantee Coca-Cola that, hey, we are promising to pay you 50 million on behalf of this person should he fail to pay. Okay, so you guarantee that you'll pay. So Coca-Cola will give you their beverages, they'll give you their trucks, whatever they're giving you, you go and sell, and then you come and pay them. If you don't pay them, Coca-Cola will go for the bank that guaranteed that loan. Are we together? That is clear. That is very clear. So please let us go to the contents. I've said first the name and description of parties, and number two, the amount guaranteed, the term guaranteed, and who is. I mean, when I say the term, I mean for how long? Bank guarantees don't go forever. They are usually for a specified period of time. That is contracts of guarantee. And then lastly is a question of, guys, is a letter. A bank guarantee is just a letter that is addressed to a person. So if you're giving me the bank guarantee, you send it to me. Your letterhead, my letter to address to me, subject, you indicate guarantee of this amount of money on behalf of this person, and then you just give me the information that we have accepted to guarantee this person for this much, for this project, for this contract. This a bank guarantee is valid until then. Yours faithfully or sincerely, that. Okay. Now, lastly is a contract of the distribution contract, a contract of distribution, a distributorship agreement, where we are simply saying that you enter into an agreement to distribute some products from a manufacturer, for instance. And I've said Coca-Cola, and most of the things, most of the trucks you see on the road written Coca-Cola, they don't belong to Coca-Cola like the company itself. Okay, they belong to the distributors. So if you are Coca-Cola and you're producing your products, let's say in Nairobi, the CBD, then you will want people to go and distribute your items in Mombasa, Narok, Kisumu. So in that instance, because you don't want to incur expenses of hiring employees and sending them to Narok or the places you want to distribute to, you look for a distributor who can go and distribute in that area. Okay, so the distributor will come for your items, they will go and sell. So they buy from you and then they go and sell in that specific region or location. Are we together? So that is a distributorship agreement. Now, what goes into that distributorship agreement? Name and description of parties. Okay, name and if you're told to prepare an agreement and you don't know what to write, just name the description of parties. Go to applicable law, dispute resolution, attestation, and execution. You're done. But that would be crazy though as well. So please just have some substance in as far as these contracts are are concerned. So in terms of distributorship, I've said the first one is, again, name and description of parties. You need to know who the parties are. That is name and description of parties. The second one that you need to know, apart from name and description of parties, you need to know the products that are supposed to be distributed. You need to know the region, the location for distribution. You need to know the price. How much are you going to be selling them for? What is the buying price and what is the selling price? What do I mean by buying price and selling price? So if you go to Safaricom, you are buying from them. Sorry, give me 1 second. Sorry about that. So I'm saying, if you go to Safaricom, you're buying from them. Are you together? So that's the buying price. If you go to Narok, you are now selling. Okay, you're selling. So that is the selling price. If you buy your newspaper from Nation so that you can resell, when you go to Nation as a distributor, you buy. So we have to agree on the buying price and we must also agree on the selling price. Okay. And then another thing that must be there is the exclusivity, an exclusivity clause where the parties must agree, are we being exclusive? It means, are you distributing just through me alone, or are you also contracting other distributors? Or are you going to distribute my products alone, or you're also going to distribute other people's products? Okay, that is what we are calling an exclusivity agreement. Duties of parties as well, you can have that there. And the obvious clauses, the boilerplate clauses, such as the question to do with applicable law, dispute resolution, attestation, execution, all those are that. So guys, let's go to tax and see what tax has to offer. For taxes, we make it quick and simple. Sources of government revenue, I don't think that is something we need to discuss because of time. Sources of government revenue is something we know. Uses of government revenue, what the government does with this money, again, that is something we all know. Principles of taxation, we know that, guys. Again, we don't need to discuss the principle of taxation as well. Types of taxes are very, very important. Again, you need to understand the types of taxes that we have. You can be told to discuss the various types of taxes that will be accruing from that specific transaction. So you just need to understand the different types of taxes that we have, as much as you can remember. Pay, CGT, stamp duty, excise, VAT, export, import, custom, corporate. There's so many types of taxes that you have. So if you're given a scenario, for instance, you'll be told that this is a company, okay? Therefore, you need to know taxes that are applicable to companies alone. Okay, so that is the question of the categories and types of taxes that we have. Now, in terms of the questions of returns, what do you need to understand about returns? In terms of returns, the law is very clear on returns that every person every person with a PIN registered as a taxpayer must file their returns. Okay, returns are are filed twice. The first instance of filing returns is the annual return that you file before the end of the month of June. That is the annual return. And then we have the monthly return. Depending on the nature of your business, we have the monthly return that is paid on certain products, such as turnover tax. You pay them monthly. So that is tax. So you have to file your returns every month or annually, depending on the type of tax. Okay. Now, apart from that, aside from that, what is the requirement on returns? So you have to file a return. If you don't file a return, there's a penalty for that. Okay. However, there's an extension of time. If you don't file a return in good time, you can always make an application to court. No, sorry, not application to court. You can always make an application to the Commissioner of Domestic Tax, asking them to give you an extension of time so that you can file a return out of time. Okay. Now, how does that work? You have to make an application. What are the timelines of making that application? If it is a monthly return, you must make an application 15 days before the due date. If it is an annual return, you must make an application 30 days before the due date. So if you are very sure that you are not going to be able to file a return this year, you have the right to make an application to the Commissioner and ask for an extension of time. If it is annual return, 30 days before the due date. If it is the monthly return, 15 days before the due date. Okay, that is as far as the returns are concerned. If you fail to, file a return, that is an offense, and you shall be fined. Okay, that is returns. In terms of assessment, again, assessment simply means you assess how much tax you owe. There are three types of assessment. There's a self-assessment, you do it yourself. As you file a nil return, what you do when you file a nil return is you're doing your own assessment. Okay, so that assessment is what we call the self-assessment. After the self-assessment, we also have what we call the default assessment. This is where you have defaulted to do the assessment yourself. So the Commissioner will do that is the Commissioner of Domestic Tax, tax, that is KRA, will do the assessment for you, and that will be called a default assessment. And then lastly, we have an advanced assessment that may be sent to you by KRA if KRA believes or they know how much you're supposed to pay this month. So they'll just send you an advanced assessment to inform you that you should pay this amount of money within this period of time. And that only happens in the instance where they already know how much you're supposed to pay. Okay, so that is the question to do with that is the question to do with the assessment and taxes. Lastly, I want us to talk about the question to do with the tax dispute. Somebody give us a summary of the tax dispute. Somebody, what is the summary of the tax dispute? Perpetual. Please unmute and talk to us. Where do you start from and where do you end? Guys, as she's speaking,
Okay.
Please, as she's speaking, take your notes and make sure you note the points very well.
Okay. So the tax dispute, you can appeal, first of all, after a tax decision has been made by the tax commissioner. If you're not satisfied with it, then you can file an objection to the tax commissioner. The tax commissioner then makes an objection decision regarding the objection filed.
Timelines, please.
Okay. I'm not sure if I got the timelines right, but let me say within 14 days. I'll confirm that, but going forward, I have the timelines. So after the objection decision, any person who's not satisfied can then file an appeal. Or the objection notice is within 30 days. You have to file the objection notice to the tax commissioner within 30 days of the tax decision. So that's the timeline. Then the commissioner has 60 days from receipt of a valid objection to decide, and failure to.
What are the conditions? Hey, what are the
Sorry?
conditions of filing an objection? The conditions of filing an objection. We are missing some points.
I think I'm not sure about that.
You can't miss that. That is
Okay.
the meat of it. That is the meat of it. You can't miss that. Somebody tell me, what are the conditions? Yes, Musao.
Sorry, the microphone was taking a bit longer, but the key condition is that you first pay what you're not objecting to before you file the objection.
Proceed.
Okay. So just from where she left, the commissioner will have 60 days to give you a response on the objection, which is the objection decision. If you're not happy with the decision, you can appeal to the Tax Appeals Tribunal. And the same conditions still stand, that as you appeal to the, I think it is a tax appeal, yes, Tax Appeal Tribunal, you need to have paid what you're not objecting to. Then they'll be able to give you a response.
Who is they'll be able, my friend?
Sorry, the tax appeal, the Tax Appeal Tribunal.
They'll be able.
They will give you a response. In the event that they don't respond, then it will be assumed that they have allowed your request.
Which request is that?
Your appeal. And the notice of appeal to TAT is supposed to be done within 30 days. Huh?
Yeah, you need to put your points clear. You need to put the points clear. Last person, Cheserek, lastly, give us a summary of that procedure. I'm not saying you're wrong. I'm just saying you need to.
The entire procedure.
Yes.
So once you have received your tax assessment, your default assessment, you, when it is in objection, you first pay the part that you do not dispute. Then within 30 days, you file an objection. You give carrier notice of objection within 30 days. Then you file your objection. You state the conditions of the objection, which are the grounds. So then once you have given this to KRA, they will make a decision within 60 days. If you are still not satisfied with the decision of KRA, you file a notice of appeal with the Tax Appeal Tribunal within 30 days. It contains the grounds of appeal and the part that you're in dispute in writing. If you're not in dispute, you pay the part which you're not in dispute. Thereafter, you will file your memorandum of appeal within 14 days, stating the grounds with a statement of facts. This will be served upon KRA within the 2 days of filing. Then you have 30 days. They have 30 days to respond. KRA will prepare a statement of fact. Then the clerk for the Tax Appeal Tribunal will give notice of hearing. So the burden of proof is on the taxpayer. And then the Tax Appeal Tribunal will give a decision.
All right. All right, Sawa, thank you very much. That is the tax decision. That is the tax appeals process. Just make sure you understand this. Should you be told to address it? Should that be a question that you need to understand or need to discuss in an exam? All right. So lastly, that I want to just indicate, I will not talk much about it. I will just project it on my screen and say nothing about it. That is the calculation of CGT, because I'm sure we have done this over and over again. how do you calculate CGT? How do you pay? How do you calculate CGT? Again, how do you calculate stamp duty? Stamp duty, you know very well in terms of how much stamp duty will be. What are the rates of stamp duty? What is the rate of CGT? And all that. We've discussed this, guys, over and over again. I don't think it's something that is troublesome like that. So it will be on my screen. That is the last bit about that. Guys, also as we go into the exam, please make sure you also look at some of the exemptions of CGT and stamp duty as well. CGT and stamp duty as well. Make sure you also get the exemptions. When are you not supposed to charge CGT? When are you not supposed to charge the stamp duty? So this is a formula of calculating the stamp duty, sorry, the CGT, which is normally 15% of the net gain. Net gain being the transfer value minus the adjusted cost. The adjusted cost is the cost of acquisition plus the incidentals, and we have done that number there. So you can take a screenshot of that, or I can send that to the group, whichever is easier, so that we've done it over and over again in this class, guys. So with your blessings, I think I want us to stop there in terms of taxes and finish our last topic, which is national payment systems. And then we can take as many questions as possible. We have really made it quick and made it fast, though time is capturing our eyes as well. All right. Is there trouble with so I will leave that for a minute. That is calculation of CGT on the screen for a minute, so that you can look at it and also familiarize yourself with what is there. If you're not understanding what is there, you can ask questions. So in terms of national payment systems, this is a system that is put in place to facilitate the movement of money from one person to the other. Movement of money from one person to the other. Are we together? All right. So who are the players in the payment system? Who are the players in the survey? Sorry, who are the players in the payment system? Who are the players? Okay, or the users of the payment system. So of course, the government of Kenya, the Central Bank of Kenya, the commercial banks, the mobile card industry. I mean the mobile money industries. We have the card industry as well. The payment card industries such as the Visas, the Mastercard, Apple. Those are the companies that make the cards which facilitate payment. We have the microfinances, Kenya Women, Faulu, All Mutual. Those are microfinances as well. Also, we have the end users, that is you and I. Okay. Now, in terms of types of payment systems, what are we talking about? The first one is the low value payment system and large value payment system. So what are the large value payment systems? Let us start with the large value payment system. Sorry. So in terms of large value payment systems, these are payment systems that are put in place to facilitate the payment of large amount of money. So let me just call it that, large amount of money, large value payment, gross payments. Okay, such as number one, anything that is above 1 million is considered as a gross payment. Anything that is above 1 million is considered as a large value payment. Okay, so if you have 1 million shillings, or you are facilitating payment of 1 million and above, it is considered large value payment system. So what are the large value payment systems that we have? We have the domestic one, that is the Kenya Electronic Payment and Settlement System. Okay, that is housed at the CBK, the Central Bank of Kenya. The system uses the RTGS to facilitate the movement of money, and in this case, money that is in large value, the movement of large value payments from one entity or one person to the other. That is the Kenya Electronic Payment and Settlement System. Number two, we have the East African Payment System. East African Payment System. That is a system that facilitates the payment of money or the movement of money within the East African. That is also large value payment system. We also have the regional payment and settlement system that now operates within the COMESA. Those are the large value payments we have. The Kenya Electronic Payment System, that is the KEPSA that we have, the Kenyan level. We have the East African Payment System, that is the one that operates within the EAC, and then we have the one that operates within the COMESA, that is the Regional Payment and Settlement System, that is the one that operates within the COMESA region. So all those, they operate or they facilitate the movement of money, and in this case, the large value payments. Okay. Apart from that, apart from the retail, the wholesale payment systems. Now we have the retail payment systems, which is the low value payment systems. Low value payment systems are payment systems that facilitates the movement of anything that is below $1 million shilling. That is low value payment. Okay. And which are these? Number one of these is the question to do with mobile money, service providers, Safaricom, Airtel. Okay, that is number one. Number two, we have the mobile. So not the mobile, but we have the card industry, the payment card industries. Okay, such as of course Visa, Mastercard, all those card industries that we have. Okay. Apart from that, we have the Nairobi Clearance House. Nairobi Clearance House, that is the house that facilitates the clearance of checks. So if you write a check, which is a low value payment system, then that will be cleared within within the clearance house. So that is a check. Checks is a system that facilitates low value payments. You can't have a check of more than $1 million shillings. It will take years and years to clear. So you can only have a check of less than $1 million shillings. If you want to pay 2 million to somebody, write 4 checks. Okay, it will clear within the normal within the shortest time possible. So checks are considered low value payment systems because they don't encourage checks of more than $1 million shillings. Apart from that, we have now the mobile banking system, or the electronic banking systems that we have that facilitates movement of money from your bank account to your mobile number and all that. Okay, so we have the credit cards and debit cards as well. I've already explained that. So those are the low value payment systems that we have. Okay, aside from that, you need to understand the role of the Central Bank of Kenya. What is the role of Central Bank of Kenya in as far as payment system is concerned? The first one, of course, it's the one that formulates the monetary policy. It implements the monetary policy. It licenses the financial operators such as banks and microfinances. It implements regulations, the financial regulations, provides liquidity, prints money, a lender to the government, a lender to the commercial banks as well. Okay, so that is the role of the CBK. There's so many things that the CBK can do, issuing banknotes, like you see a notice today, indicating that yesterday, that the bank will be issuing new notes. That is the role of the CBK. Okay. Now, after the question of the role of the Central Bank of Kenya, you need to understand also the question of licensing of digital lenders. Okay, you've seen this. It has been a topic for some time that all digital lenders, those that offer lending services online, must be licensed. All of them must be licensed. Okay, so the Central Bank of Kenya has made sure that you must apply for a license for you to be able to operate a digital lending system. Are we together? So that is that. So in as far as digital lenders are concerned, I want you to go and look at some of the things that the central bank has done to ensure consumer protection. Okay, if you look at the digital lenders regulations that has been rolled out by the central bank, down there you're going to find two things: how central bank ensures there's no money laundering, and also how central bank has ensured that there is there is the question to do with consumer protection, such as no false advertisement, the borrower must be given the receipt, consumer complaint mechanism must be put in place, data protection to ensure that you don't access unauthorized access of I mean the subject's data information, questions to do with the safety of the information acquired, things to do with the terms and conditions that must be provided by these digital lenders. They have to show you the terms and conditions so that you know what you're dealing, you're putting yourself in. So guys, those are some of the things you need to understand. In as far as lending is concerned digitally, okay? Aside from that, also you need to understand the question to do with data protection, which is the last bit of this thing, which is the question to do with what are some of the things you need to do when it comes to data protection. So in terms of data protection, just understand the rights of a data subject. What are the rights of a data subject, or what information will be classified as a sensitive data, or personal data. In that instance, the name, ID, biometrics, health data, all those that are within the Data Protection Act. Also understand the question to do with the registration of data handlers, and processors, controllers and processors. Also understand the question to do with transfer of personal data. How do you transfer personal data from Kenya to somewhere else, or within Kenya? What are some of the things you need to understand? The question of consent of the data subject at all times must also be understood. All right, so I'm just asking you to skim through the Data Protection Act. I'm asking you to skim through the Data Protection Act so that you don't miss anything. Should there be a question on data protection? We've seen them attempting to set a question like that previously, but I'm not saying they will not repeat it again. I'm just saying they might repeat it. So you need to also have your arms and legs wrapped around that point as well. Now, something also I need to mention is the question of registration of payment service providers. Payment service providers. Now, in terms of national payment systems, we are simply saying that you are providing a mechanism of payment, whether it is M-Pesa, whether it is e-banking, whether it is whichever payment service that you want to offer. It means you are providing a payment solution to people. Okay, if you are providing a payment solution, then you must be registered by the Central Bank of Kenya to provide a payment service. What are these payment services that we're talking about? Things like M-Pesa. You can't operate an M-Pesa without being licensed. So Safaricom must be licensed to even operate that. So you have to be licensed as a payment service provider. Now, what do you need to do? You must apply to the Central Bank of Kenya in the requisite form, the prescribed form. Make an application. If you make that application, what do you need to show? What are the contents of the documents that you need to have when it comes to this application for registration or recognition as a payment service provider? Of course, the name and registration of the company that is providing the payment. You must have the memorandum of association of that company, the article of association, the list and information of directors. You need the certificate of incorporation. You need the the board resolutions as well. You need the statement of financial position, and also you need a minimum capital of around 5 million shillings, but between 1 million shillings, depending on the nature of your business and the business plan that you want to do. Okay, so that is the question to do with licensing of payment service providers. So you understand that bit. Also, you understand the question of digital lenders. Also, you understand the question of data protection, and also you understand the question of the payment services in terms of what they are, the types, and the players, and what role the Central Bank of Kenya is playing. Okay. After saying that, what I've said right now, that should mark the end of today's class. I'm open to a lot of questions, as much as you want to ask, and then we can proceed. And so I hope you've noted down your questions. So please, you put up your hand. You ask your questions, and then we go to the next person. Ask their question, we answer them. And that means anything from MPSR moving across to what I just mentioned right now. Okay, so you have that opportunity right now to ask so that you can be answered. All right, let's start with Kandagol. Okay, not there. Olivia?
Oh, mine is just seeking clarification in terms or when you in the procedure when you want to register the joint venture, is it does the notification come first before the incorporation, or the incorporation comes first before the notification?
You have to notify first. Sorry, I failed to mention that. Yes, you have to notify in terms of joint venture notification. Anytime you're coming up with a joint venture, you have to notify the competition authority, and you just do the venture. The merger notification form plus the documents we said that you attach. The same you'll do for joint venture. So you have to notify once you get the approval, then you proceed and notify. Proceed and incorporate your joint venture. All right. Doris?
That to joint ventures, you talked about something green. Green what? Just a moment. You talked about the two types, the green leaf and the other one. Are you able? Please explain what they mean.
No, you can't tell me that. I already explained what they are. So tell me the exact question you have. I explained that. Unless you want me to go talk about joint ventures right now, which is very unfair. What is the exact question you have?
Is the description?
You didn't get anything. That's what you're saying. You didn't get anything about what I said. Hapana kenye ulishika hata kidogo.
I need help understanding those two types, what they mean.
What
I
did
didn't
you
understand the description.
Let's start with what you had, not what you understood. What did you hear?
Okay, I understand description of a joint venture.
The types.
For the types, honestly, I did not understand because I didn't understand those two because I only know about the definition of the joint venture. I don't know about
Leave alone what you understood. I'm asking you what you heard. What did you hear me say? And then we can pick from there and see. What did you hear me say about Greenleaf and full function joint venture? What did you hear?
I just heard that the joint venture, the full function is independent. I'm not sure independent of what exactly. I missed the definitions.
And then Greenleaf?
Honestly, I don't know.
All right. So Greenleaf, we say this is where the joint venture is doing something that the parent companies are not doing. It's a new thing. They're coming up with a new venture. It's a new thing. Like if the parent companies are in banking, the joint venture is doing something different, maybe in marketing. If the parent companies is maybe in sales, or the parent companies are in farming, the joint venture is in banking or finance or accounting. So we are simply saying that when the joint venture is doing something that is totally new or totally different from what the parent companies are actually doing, that is a greenleaf joint venture. Are we together?
Yes.
And I said a full function joint venture is a function that is a joint venture that is independent from the parent companies. It is fully functional. It is independent. It is independent. It is, I don't know how I can explain independence in this nature, but it is independent. It has a full function. It does not rely on the parent companies. It is full. It has its own directors, its own management, accounting. It has its suppliers. It has its own flow of everything. The company is entirely a different entity that has its own structures, that doesn't rely on other, the parent companies. Are we together?
Yes.
So what is the difference? What are the two?
The difference is that for Greenleaf joint venture, the parent company is doing a completely different kind of business from the from they're doing complete different functions. Or the purpose for the company was completely different from the other. So maybe
Which
one
is
is in agriculture.
Hey.
Yes.
What is the other? That is not what I've explained. What is the other?
Venture from the other venture.
Which other venture is that you're making reference to?
The venture that they are uniting to. There are two companies that are uniting to perform a specific function. So one of the companies is doing agriculture, and the other company is probably in tech. So they are. That's now the distinction.
Who has told you that, Doris? Who has told you that? Where have you heard that from? Is that what I've explained right now? Is that so? Doris,
Yes.
is that what I've explained? No, it's not. I've said a Greenleaf joint venture is a joint venture where the joint venture itself is doing something different from the parent companies. You've not heard me say that.
Understood.
So what is the difference?
The joint venture is doing something completely different from the parent companies. Is that what you said? Yes.
Give me the difference between the two things. That is the Greenleaf and full function. Quickly, make it quick. People are online. People are waiting to ask questions.
For the full function joint venture, it does not rely on the parent company. It acts independently, from the parent company.
Let's do this. Let me explain one more time. Let's go together. Are we there? Are you there with me? Are you there with me? Can we go together? Are you
Yes, I
there?
am here. Yes, I am here.
All
Yes, I
right.
am
So
here.
greenleaf is whereby green means new. When somebody says green, something green, new, it's greenleaf. Okay. A greenleaf joint venture is whereby, what is a joint venture first? A joint venture is an entity that is created by two companies. two companies will come together to form another entity called a joint venture. So they are the parent company, just like two parents will give birth to one child. That child is the joint venture. Okay. Now, if this joint venture is created for purposes of doing something different or new market that these parent companies have never done, that is a green leaf. Normally, when joint ventures are created, they just further the things that they've been doing. For instance, if I have a joint venture, so if Safaricom and Airtel have a joint venture, the joint venture will normally be on the question of communication, M-Pesa and Airtel money. And therefore, that is not greenleaf because it's the same thing that the parent companies will be doing. However, if they come up with a joint venture to do something different from what the parent companies are doing, if their main operation or business is different from that one of the parent company, that is greenleaf. Are we together there, mpaka hapo, Doris?
Yes.
Good. Now, the next one is the question to do with full function. Now, full function is whereby this child that you have, if you give birth to a child, the child that you have grows old, let's say up to the age of 18. From the age of 18, this child needs to walk out of your house and go and find another place to stay. You know, you move out of your parents' house, you are considered an adult. Okay, so a full function joint venture is like that. It's a joint venture that doesn't rely on the parents, that is the parent companies. It has its own independent structures, independent accounts, independent management, independent customers, independent suppliers, independent. It has everything independent. So it can independent assets and everything else. So it can operate independently from the parent companies. Okay, why is that a case? It is a case because most joint ventures rely on the parent companies to operate. Tuko sawa, my friend Doris?
Yes, we are together.
All right. So
Thank
my assumption is that you understand the difference now, right?
Yes, I've understood. Thank you.
Good. Sawa, thank you very much. Mulongo.
Apologies, the muting button was a bit problematic. My question basically goes to the aspect of charity activities and what special vehicle should be created to advance such cause.
What do you
Now,
think?
the question basically comes earlier last month, the Public Benefit Organization was enacted and came to full effect. So typically, if that question could have been brought, I would have thought maybe the best vehicle that I could use was a private company limited by guarantee. But now that we have a public benefit organization, it throws the spanners into the works, and I'm quite confused. If such question arise, how do I
If somebody wants to